Hi, my name is Matt Rames-Cole. I'm part of the management team of the Advice Lines here at Crona. So today I'm here to talk about the changes that were made in employment law with effect from April 2019 and to look ahead to some of the changes that are proposed connected to the Good Work Plan that are coming into effect from 2020. The first of those changes I wanted to talk about were the increases to the national minimum wage rates, which increase, generally speaking, every April. This year they increased again on the 1st of April 2019, increasing across the board by 4.9%. The actual pay rate depends on the worker's age, and so for those that are classified as apprentices, the rate increased to £3.90 per hour. For those that are 18 or under, the rate increased to £4.35 per hour. For those 18 to 20, the rate increased to £6.15 per hour. For those that are 21 to 24, the rate increased to £7.70 per hour, and for those that are 25 and over, which is also known as the legal living wage, the rate increased to £8.21 per hour. In the last 12 months, so in 2018, the government named and shamed 419 employers, requiring them to pay just over £2.5 million in minimum wage arrears and fines. So as of the 6th of April 2019, it's now a requirement that you provide an itemised payslip to all workers, whereas historically this was only something that had to be provided to those that had employment status. There are also a requirement that you provide additional information within the itemised payslip. The itemised payslip does unfortunately mean that it's easier for HMRC and others to pick up any underpayments to do with minimum wage and also holiday pay. But obviously it's important therefore the information on there is correct and accurate and that you are correctly paying those amounts to your staff as well. If you're unsure of what needs to be included within the itemised payslip, then a sample can be downloaded from the free section of the Crona website. So another major change that came in with effect from the 6th of April was the increase to pension contributions for auto-enrolment. The rates that have to be paid into the pension pots have increased so that employee contributions now have to be a minimum of 5%. The employer contribution should be a minimum of 3%, giving a total contribution into the pot of 8%. Obviously, if the employer wishes to be more generous, taking the total above 8%, then they can do so, but the employee must still contribute based on the 5%. So also changing with effect this time from the 7th of April was the increase in the statutory pay rates for the various different family-friendly rights, which increased from £145.18 per week to £148.68 per week. These are the rates that are applicable for the various different types of leave, such as maternity leave, adoption leave and paternity leave. The eligibility criteria for these rights remained exactly the same, albeit that the lower earnings limit for making national insurance contributions, which is one of the eligibility criteria, the average that an individual needs to earn over the qualifying period rose from £116 per week to £118 per week. So I also wanted to talk about the Good Work Plan, which is due to come into force with effect from April 2020. The plan has been dubbed as the biggest overhaul in employment law for the last 20 years, and it's come about as a result of the Taylor Review and subsequent report that was carried out in relation to the gig economy. Some bits of the plan are actually still pending further clarification, but there are some aspects that you can start to prepare for now. So one of the things that is changing is that the requirement to provide a written statement of the basic terms of the contract is being extended from employees to workers, and also that this then has to be provided from day one of the employment or the relationship starting, rather than within the first 2 months, which is the current requirement. It's also only currently available, or a requirement that it's provided to employees, so as I say, this is being extended for workers as well. Another change is the right to request a stable contract for those that are working on a flexible arrangement, so those that are 0 hours employees or 0 hours workers. So they'll have a right to request a stable contract once they've actually been under an arrangement for 26 weeks. The details still to be finalised here, however it's expected that the process would follow the same as it currently does for those that are requesting flexible working, and that any request for a stable contract would have to be dealt with within 3 months. Also changing is the length of time that would be considered to break continuous service, which is relevant for an individual being able to access various different employment rights. Currently the break-in service is as short as a week with a weekend either side, and this will be increased to 4 weeks. Obviously this means that there will be more individuals that are able to exercise these rights, particularly the right to unfair dismissal, which has a 2-year requirement. And so it's important to make sure that you are correctly monitoring and maintaining records to ensure that you're quite clear in terms of who potentially has access to which rights and who doesn't. Also changing is a prohibition on employers, particularly obviously in the hospitality sector, from being able to take an administration fee from tips and gratuities that are left by customers or provided by customers for staff. The government's aim here is to try and ensure that where tips and gratuities are left for staff, that the money does find its way in full through to the staff. For agency workers, they are going to be entitled to a key facts document that will set out the certain terms and conditions and certain aspects of the arrangement that they're entering into with the agency, just so that they're clearer in terms of some of the key areas and key aspects of the arrangement that are going to be in operation moving forwards. So I hope that you found this to be helpful, but if you do have any questions in relation to anything that we've discussed today or on any other aspect of employment law or employment relations issue that you're facing, contact one of our experts today on 0808 145 3488.